45 states today have reaffirmed that a marriage is in fact a union of one man and one woman. And it is absolutely inconceivable to me that the authors of the Constitution ever intended to create a right to same-sex marriage. So I do not understand how any judge could find that it was contrary to the Constitution to have a majority of the voters of a state weigh in on their opinion. It really goes to the core of democracy and the right of the American people to determine for themselves what the laws and rules ought to be, which are constitutional. Legalizing an alternative form of marriage dilutes a long-standing and widely accepted standard of marriage as a union between a man and a woman. We should adhere to such standards rather than undertake a massive social experiment with perhaps unknown consequences.
Frankly, I believe that progressive activist judges who issue their personal moral pronouncements under the guise of constitutional law are instead demonstrating themselves irrational rulings. And in this case, I think we can expect to see Judge Walker's ruling appealed to the U.S. Ninth Circuit and then end up at the Supreme Court. But we really need to ask ourselves the questions. Are we now in the position of giving a judge the decision to decide whether or not the American people are rational when they go to the voting booth and make their wishes known? It certainly seems the answer would be in the negative.